seated. Veuillez vous asseoir.
Good morning, Mr. President. Situation in Darfur, Sudan. Case the prosecutor versus Mr. Ali Muhammad Ali Abdulrahman. Case reference ICC 0205 0120, and we are in open session.
Should I start from the beginning? Yes, okay. I am Judge Piotr Hofmański, presiding judge, and this appeal arising from the case of the prosecutor against Ali Muhammad Ali Abdulrahman. My fellow judges in this appeal are Judge Chile Boyasuji, Judge Howard Morrison, Judge Luz del Carmen Ibanez Carranza, and Judge Salome Balungi Bossa. May I ask the parties to introduce themselves for the record, please, starting with the defense.
Bonjour, Monsieur le Président. Du côté de la défense, pour assister Monsieur Abdulrahman ce matin, Cyril Lauchi, conseil principal. Les diverses quarantaines dues au Covid ont empêché le reste de l'équipe d'être présent, mais nos confrères du bureau du Conseil public pour la défense, Xavier Jean Keita et Madame Vedrana Rezidovic, nous ont fait l'amitié de nous accompagner. Je vous remercie.
Thank you.
Bonjour, Monsieur le Président. Xavier Jean Keita, conseil principal au PCD, et avec moi aujourd'hui pour accompagner Maître Lauchi, Madame Vedrana Rezidovic, gestionnaire de dossier, case manager. Je vous remercie.
Thank you. And the Office of the Prosecutor, please.
Good morning, Your Honour. My name is Helen Brady. I'm the Senior Appeals Counsel for the prosecution, and I'm here today with Mr. Matteo Costi, Appeals Counsel, and Mr. Julian Nichols, the Senior Trial Lawyer in the case. Thank you very much.
Thank you, Mr. Brady. Thank you very much. For the records, I note that Mr. Abdulrahman is also present in the courtroom. Today, the Appeals Chamber will deliver its judgment in the appeal of the Mr. Abdulrahman against the decision of the Pretrial Chamber 2 of 14 August 2020 entitled Decision on the Defense Request for Interim Release. This is a non-authoritative summary of the Appeals Chamber written judgment in the appeal. The letter will be notified after this hearing together with the separate concurring opinion by Judge Ibanez Carranza. Before I turn to the matter of today's hearing, I note that on 5th October 2020, counsel for Mr. Abdulrahman filed a motion requesting that Mr. Abdulrahman be authorized, preferably before the delivery of the present judgment, to observe 1 minute of silence in memory of the victims of the armed conflict in Darfur, Sudan. The purpose of today's hearing is the reading of the summary of the Appeals Chamber's judgment on Mr. Abdulrahman, appeal against the pretrial decision on his request for interim release. In these circumstances, Mr. Abdulrahman's request on 5th October is dismissed in limine. I shall now turn to the summary of the judgment, and I will briefly outline the procedural history of this appeal. On 14 August 2020, the pretrial chamber rejected Mr. Abdulrahman's request for interim release to the territory of the host state pending trial pursuant to Article 16, paragraph 2 of the statute. In this decision, which I shall refer to as the impugned decision, that is the object of Mr. Abdulrahman's appeal. The impugned decision is based on the pre-trial chamber conclusion that Mr. Abdulrahman continued detention appears necessary to ensure that the investigation of the court proceeding are not obstructed or endangered. In this regard, the pre-trial chamber considered, first, the prosecutor's submission that she is not yet in a position to protect witness in Darfur. Second, the report of threats allegedly made by Mr. Abdulrahman and his supporters to human rights activists. And third, the alleged high-ranking position previously held by Mr. Abdulrahman in Darfur, his connections and the likelihood that he still has supporters who may have access to actual and potential witnesses. The pre-trial chamber further found that any risk to the investigation, the proceedings and the safety of witnesses would not be sufficiently mitigated by imposing conditions upon interim release. Furthermore, the pre-trial chamber held that for the purpose of its decision it did not consider it necessary to seek observation from the host state. Mr. Abdulrahman filed his appeal brief on 19 August 2020 and the prosecutor filed her response on 31st August 2020. Mr. Abdulrahman requests the appeal chamber to reverse the impugned decision, order his interim release to the territory of the host state, subject to any relevant conditions, and to order, and I quote, the immediate commencement of the consultations with the host state. For that purpose, Mr. Abdulrahman raises 5 grounds of appeal, which I will address in turn. First ground of appeal. Mr. Abdulrahman submits inter alia that the pre-trial chamber erred in relying on the prosecutor's inability to protect her witnesses in Darfur. In this regard, Mr. Abdulrahman argues that his inability must not adversely affect his right to interim release. Further, he submits that the prosecutor currently has no means of conducting investigations in Darfur. The appeals chamber finds by majority that this ground fails. First, the appeals chamber notes that the pre-trial chamber's reliance on the prosecutor's inability to protect witnesses in Darfur cannot be assessed in isolation. This is because, for the purpose of its finding, the pre-trial chamber considered the available information holistically. Notably, and in addition to the prosecutor's inability to protect witnesses, this information included a report on threats allegedly made by Mr. Abdulrahman and his supporters to human rights activists. It also relied on the information provided in the 2 warrants of arrests concerning Mr. Abdulrahman, position and the likelihood that he still has supporters who may have access to actual and potential witnesses. Second, the appeals chamber finds that the pre-trial chamber, in considering the prosecutor's alleged inability to protect witnesses in Darfur, acted in line with its obligation under Article 68 of the statute to ensure the protection of victims and witnesses. I shall now turn to the second ground of appeal. Mr. Abdulrahman argues that the pre-trial chamber erred in relying on NGO report appended to the prosecutor's response as Annex 3 for its finding that there was an appearance that the Mr. Abdulrahman and his supporters have threatened human rights activists. The appeals chamber finds that, contrary to Mr. Abdulrahman's argument, the pre-trial chamber did not commit any error of law concerning the standard applied when relying on Annex 3. It also notes that Mr. Abdulrahman's submission that Annex 3 was the sole basis underlying the pretrial chamber's conclusion appears to be based on a misreading of the impunity decision. In this regard, I recall that for the purpose of its finding, the pretrial chamber relied on various factors holistically. As a result, any limitations concerning the evidentiary value that Annex 3 might have if it were to be considered in isolation are irrelevant. The Peace Chamber also finds that the impunity decision is not impacted by any factual errors allegedly committed in this respect. I will now address the third ground of appeal. Mr. Abdulrahman avers that the pretrial chamber's conclusion to keep him in detention due to existence of an unacceptable risk that he may exert pressure on witnesses is erroneous in fact and law because it fails to take into account a series of factors. The Peace Chamber is satisfied that the pretrial chamber considered all relevant factors and provided sufficient reason for its conclusion. Specifically, the Peace Chamber notes Mr. Abdulrahman's arguments that the pretrial chamber erred by failing to distinguish between witnesses residing in Darfur and witnesses residing in other countries. In this regard, the Peace Chamber observes that the pretrial chamber found that the interim release would expose any kind of witnesses to an unacceptable risk. Consequently, the Peace Chamber considers that Mr. Abdulrahman failed to articulate how the alleged error lack of distinction would amount to an error. I will continue with the fourth ground of appeal. Mr. Abdulrahman avers that the pretrial chamber reversed the principle that detention is an exception and not the rule. The Peace Chamber finds that most of the arguments under this ground have already been brought under the first and three grounds of appeal and warrant no further consideration. Regarding the remaining arguments, Mr. Abdulrahman elaborates on the circumstances of his surrender to the court and his willingness to comply with stringent security conditions, which in his view would militate in favor of his release. The Peace Chamber notes that the pretrial chamber explicitly recalled the principle that detention remains the exception and duly considered all the factors relied upon by Mr. Abdulrahman. The Peace Chamber finds no error in the pretrial chamber's conclusion that these factors were insufficient to mitigate the risk to the integrity of the investigation and the proceedings and the safety of witnesses. I will continue with the fifth ground of appeal. Mr. Abdulrahman argues that the pretrial chamber committed an error of law by failing to seek observation from the host state as required under Regulation 51 of the regulations of the court. The Peace Chamber finds by majority that his argument is unsupported by the applicable legal framework and the case law of this court. Rather, the Peace Chamber finds that the chamber hearing an application for interim release and in the absence of any prospect for the application to succeed, has no general obligation to seek observation from the host state and or the state on the territory of which interim release is sought. Finally, in an appeal pursuant to Article 82(1)(a) of the statute, the appeals chamber might confirm, reverse, or amend the decision appealed. In the present case, given that the appeals chamber has rejected all 5 grounds of appeal, it is appropriate to confirm the impugned decision. Judge Ibanez Carranza is appending a separate concurring opinion on the issues on the recharacterization of the alleged error presented by Mr. Abdulrahman under the first ground of appeal and on the interpretation of Regulation 51 of the regulations of the court under the 5th ground of appeal. This brings us to the end of the summary of the Appeals Chamber judgment. I would like to thank the court reporters, interpreters, the registry, staff for the valuable assistance today in holding the hearing. The hearing is adjourned.
All rise.